Good afternoon and welcome to the March webinar presented by the Recruitment, Training and Support Center at the Federation for Children with Special Needs. My name is Janie Greco and I am the Training and Support Specialist at RTSC. Today's webinar is the Model Code of Conduct, Working with Schools to Advance the Rules of Discipline. Our presenter today is Marlies Spanjaard, Director of Education Advocacy for the Edlaw Project. She is responsible for supervising staff attorneys and interns, making program-wide policy decisions, and conducting statewide trainings on education-related topics. She has represented students in school disciplinary hearings, team meetings, and before the Bureau of Special Education Appeals. She is also an adjunct instructor at Wheelock. During the webinar, please type your questions in the toolbox and feel free to engage with other attendees. We will leave time at the end of the hour to address the questions. If your question is not answered live, please send us an email and we will try to do our best to follow up with you. Our technical producer today is Renee Williams. If you are interested in learning more about the Federation, please go to our website at fcsn.org and explore all the different programs, including how to volunteer to become a special education surrogate parent. Marlies, welcome, and thank you so much for being here.
Thank you, Janie. So I wanted to first start by kind of introducing the project that I work for is the Edlaw Project, just to give a little background of who I am and my thoughts and passions about this issue. So we were originally created in 2000 as a partnership between the Children's Law Center of Massachusetts and the Youth Advocacy Project of CPCS, or Committee for Public Counsel Services in Roxbury, which is the Juvenile Public Defender's Office. And essentially we were created as a way to try and intervene in the school-to-prison pipeline, with the idea being that if kids are on track educationally, then they are less likely to be court-involved, and if they are already court-involved, that hopefully getting them on track educationally will stop that court involvement. So we were, for about 10 years, handling just Boston area cases. We did about 1,000 cases, as Janie said in the introduction, discipline, special ed, BSEA stuff, all of that. And then in 2011, there was a kind of restructuring in the public defender division, and instead of just the one office in Roxbury, there were now 9 statewide offices across the state. And so the Edlaw Project, instead of just being focused on Boston and direct representation, switched our focus a bit to training and support of not only attorneys at the Juvenile Public Defender's Office, meaning attorneys representing kids in delinquency, but also attorneys that are working with kids in the child welfare system. So essentially our goal is to work with any court-involved child to see what we can do to make sure that they have success in education. So that's kind of where my background is. I know that a lot of the attendees are special ed surrogate parents, and so we are perhaps working with some similar children. So that's my background, and now let's kind of get into the thick of it. So I wanted to start with just a background, and I know there have been some webinars in the past on Chapter 222 and school discipline. So I just want to do some, I'll go through these fairly quick. I want to go just basically the basis of school discipline and due process in Massachusetts, so that we can see what is required and what is a choice by the legislature, and then also when a school district chooses things as well. So, you know, the due process in Massachusetts comes from a number of different areas. One is Goss v. Lopez, which is a United States Supreme Court case which sets the federal standard, which we'll talk about in a minute. There's state law, so there's Chapter 71, Section 37H, H1/2, and H3/4, which is the new one. And then now we have, for the first time, new state regulations, which are 603 CMR 53. And then there's some case law about some of the serious offenses that is also gives us some additional information on the due process. So Goss v. Lopez was a case in Ohio where basically it was a giant food fight, and I think they said up to 50 students, 45 or 50 students were actually suspended for the food fight, but there were 9 students that were given a 10-day suspension without any hearing, and they were not happy about that, and their families were not happy about that, so they filed in federal court to assert their protections, and it went all the way up to the Supreme Court. And this is essentially the only Supreme Court case on due process, and it says that students have a legitimate property interest in their education, which can't be taken away without procedural hearing. But what that ended up meaning was that what the Supreme Court said was that if you're going to remove a child for less than 10 days, they only need to be given notice and an opportunity to be heard. And if it's going to be for more than 10 days, the Supreme Court did not get very specific about what is required, just that it may require more formal proceedings, and listed a few things like written notice of the charges, the statement of the evidence, and the right to be represented. And that is essentially the only federal law on school discipline. And it's not super instructive. So then, that's the floor. The federal standard is the floor, and then states have to at least meet the floor and can do better. So then let's talk about Massachusetts. So Massachusetts due process has essentially broken down the offenses into serious offenses and non-serious offenses. And serious offenses are 37H and H and a half. Essentially, 37H, or as I like to call it, or a number of people do, the 3 deadly sins. The possession of weapons or drugs at school, and assault on educational staff. That can get you in a lot of trouble, which we will discuss. And then Chapter 71, Section 37H and a half is the felony complaint or conviction, which essentially says that if there's an outside court case, that could be a problem for you and could lead to school discipline. And then there's the non-serious offenses, which is 37H and 3/4, and the regulations that basically covers everything else that isn't covered in 37H and H and a half. So the first thing that's important to note about 37H is that it specifically carves out a statutory, it has the statutory authority for having codes of conduct. So it essentially says that the superintendent of every school district has to publish their procedures and their policies pertaining to the conduct of teachers and students, and that copies of these policies shall be provided to any student upon request and without cost. So every district should have a code of conduct, and it should be available to anyone who asks free of charge. They go by other names, so sometimes they are called a student handbook, sometimes they're called the student discipline handbook, sometimes they're called the code of discipline or the code of conduct. Most are available online these days, so just going to the school district website and searching for student handbook or policies or discipline usually brings it up. I haven't had a lot of difficulty in the last, I would say, 5 years finding them online. Another option, if you can't find it online or you do not have access to a computer or a printer, is to go to the school and say that you'd like a copy of the code of conduct, and they should have that available or be able to make that available. Okay, so in 37H, there's specific language about what is required in all of the codes of conduct. And it says specifically that you need to have information about the disciplinary procedures, what's going to happen for the suspension, expulsion of students, procedures pertaining specifically to discipline of students with special needs, which we're going to talk more specifically about in a little bit. Standards and procedures for to assure school, sorry, my phone is ringing and I'm trying to turn it off. Okay, sorry. Standards and procedures for security and safety as well. And then there's some specific things that come from other laws that say that you need to make sure that there are disciplinary measures if it's a weapon, a drug, vandalism, and violation of student civil rights. It also talks about 37H, those 3 deadly sins I referenced, which is that the principal has the authority to permanently expel students for weapons, drugs, and assault on educational staff. It lays out the appeal rights and the educational services during the period of exclusion. I'm not going to go too far into these. Like I said, I'm trying just to provide a background of what is required in each of the Code of Conducts. Okay, so this is an interesting section that is also in 37H that we should keep in mind when we start to think about advocacy. But this says that for high school, and it specifically says high school, that principals need to basically prepare and distribute to each student the student handbook with the rules pertaining to the conduct of students. It should include an age-appropriate summary, and that the school council is supposed to review this every year to look at what changes might need to be put into effect. So I'm going to just put that out there, and then let's file it away to talk about again. But one thing to note here is that, as I put in bold, it's an age-appropriate summary. It is not the full Code of Conduct. Sometimes it's just a page or two that says, for example, in Boston, it has in the student handbook that goes to students, it does mention some disciplinary actions that are, that can get you in real trouble, but it is certainly not the same as the about 60-page Code of Conduct that is the full Code of Conduct. So it really is just a summary. It does not give all the rights and responsibilities required. The other thing it says is that codes of conduct need to be filed with the Department of Ed for informational purposes only. I think it says that basically to say the DESE doesn't have specific oversight over the policies. They're not approving them. It's just, they're there for informational purposes only. I have not ever tried to get a Code of Conduct specifically from the DESE. I think it's probably easier to go to the school directly, but under 37H, they should technically have them. Then the other kind of required state statute is this Section 37H1/2, which deals with felony charges or convictions. Essentially, it says that if a student has a felony charge and the principal determines their continued presence in school would have a substantial detrimental effect on the general welfare of the school, that can lead to an indefinite suspension. And if a student has a conviction, a felony conviction or an adjudication, then that can lead to expulsion.
Marlies?
Yes.
I'm just going to interrupt for a second for a point of clarification. A couple of people are asking about the codes of conduct and whether they're school-wide or district-wide. I know a lot of schools that I've worked with, they have a different code of conduct for the elementary schools as opposed to the other levels of school. Is there an overriding code that applies to all levels of education?
Okay, so the statute's not specifically clear about that. It just says that they need to have a handbook or student handbook that has just the things that I'm delineating. So the school rules, that's up to the school. So it's very often that there are different handbooks for high school and for elementary school, and there doesn't necessarily need to be one specific overriding document. It just says that they have to have a document, and it doesn't, it certainly leaves open the possibility that there are numerous documents. It just has to be that the policies are delineated. Okay. So the other couple of statutes that are just kind of random but that are specifically stated, and so I'm just trying to again lay the floor, is that there is a littler known statute that says basically that no student should be suspended or expelled or disciplined because they got married, they're pregnant, or parenting for things that aren't connected with school sponsored activities, but there can be oversight by a district to require that a pregnant or by the school committee, excuse me, that a pregnant student be under the supervision of a physician. The 37H1/2 statute is a specific carve-out of this. So although it says for conduct which is not connected with a school-sponsored event, 37H1/2 is specifically carved out of this. And then this is another one that I don't see used very often, but I just want to put it out there, which is that if a student is unlawfully excluded, there is actually a tort right that a student could sue the school committee or any of the officers in the school district to say that basically if they were unlawfully excluded, that they can recover from the school district. I'm not aware of any situations where that has happened, but it does appear to be an option. I think it would probably be a difficult option to exercise because unlawful exclusion is tough to prove because there's a lot of discretion given to principals and superintendents when it comes to school discipline. Okay, so Chapter 222 is the new school discipline law. I know there was a webinar specifically about Chapter 222 recently, but the reason I bring it up is that it went into effect in July of 2014, and it has the new 37H 3/4, which, H1/2 wasn't enough. We have to have H 3/4, and the new regs. And this basically is the everything else category. So before, the everything else was kind of left just to schools, and now there's a state statute that says this is the everything else. And so essentially it limits the number of days out of school to 90 days in a school year. It outlines the procedure schools must follow. It outlines emergency suspension procedures. And it specifically says that young kids really shouldn't be, it's basically trying to say young kids shouldn't be suspended, and that if a school is going to suspend a student, kindergarten to 3rd grade, that the superintendent needs to be aware of that before the exclusion occurs. And it now, and this is the biggest change, is that it basically mandates that students out of school have an opportunity to make academic progress. This is both for students serving short-term suspensions as well as long-term suspensions, the difference being that long-term suspensions, once you reach 10 days and more, they actually have to provide educational services. But students on short-term suspensions still have the right to make up their work and such. Principals have a lot of discretion under 37H 3/4, but there's some great language in here about how they're supposed to be required to consider ways to re-engage students in the learning process, and that students should not be long-term suspended until other non-exclusionary methods have been tried. So this language will, again, kind of loop back in the end when we talk about advocacy, but there are now in the statutes, some really helpful language when you are trying to advocate for a student to say, look, the statute is clear that you need to re-engage the student, try and re-engage the student, and use non-exclusionary methods. Okay, so that's the mandated things in the school code of conduct. It's very broad in terms of what is then left to a school to make their own school rules. They can do that. It can be a problem to wear a hat in one school, and it may not be an issue in another school. Schools do have the authority to make their own school rules, but they do not have the authority to violate the state statutes. So everything needs to kind of fit under that. So even if they want to suspend for something, they can't do that for. You have to do that within the regulations of 37H 3/4. So all the things that state statute now stands for, the school can choose their things that are suspendable, but it has to be done in response to 37H 3/4, if that makes sense. Okay, so then looking at compliance, the first question that you really want to know is my district up to date? Some easy checks is looking for the revision date. You know, as we just discussed, the new school discipline law just went into effect July 2014. Schools did have a 2-year warning from when the law was signed to when it actually went into effect. But there should be, in all school districts, essentially a brand new code of conduct that has all the new state statutes in it. So the first thing you want to do is check for a revision date to see when a school district last updated their handbook. Usually that's just on the front cover when it says like student handbook or student code of conduct. It usually specifically says, you know, revised on this date or something like that. So that is your first place to look. And then there are, you know, some well-meaning districts who have revised their code, but it may not actually be in compliance with the new law. So checking for specific provisions of the new law in the old law, in the code of conduct. So Harvard Law School students actually made a checklist, and there were about, let's see, 1, 2, 3, 4, 5, 7 or 8 students that are working on a project that are actually looking at school code of conduct to see if they're in compliance with the new law. So I'm going to talk next about their checklists, and then I just want to say we don't have the checklist yet available to get to you, but we absolutely expect that we will have that checklist. I have been speaking with the organizer who's working with the student, and I don't think that's an issue. I only have it in a PDF form now, but once we have it available, we will make sure to get it out because it is super helpful in terms of just going through it. So I'm just going to show 3 examples, mostly just to show kind of the color and how it looks and what they have done with the checklist. So the first example is Boston Prep, and I know the writing is kind of small on your screen, so I more just want to show you that it has a key, and basically it's listed all the different sections of the regs that are new, that talk about what a school is required to do. And the students have basically come up with a key that, you know, if it's green, they're complying. If they're yellow, they're partly complying. And if they're red, then the school district is not compliant at all. And this is just page 1 of what is actually a 6-page document, I believe, that, like I said, I'm happy to share once I have it. But it breaks down the regulations. So, for example, with Boston Prep, looking at the second one, provide parent and student oral and written notice before imposing a short-term or long-term out-of-school suspension as a consequence of a disciplinary offense. That is required by the new discipline regs, and complies means that that is also listed in the due process rights in the Boston Prep Charter School Code of Conduct. None of this is to talk about whether the district is actually complying with their code in practice, but this is all an analysis, just a starting analysis of whether the district, whether their code is up to date. So Boston Prep Charter Schools starting pretty strong. Then we go to Fall River, and you start to see a little more red and yellow on the analysis. So their example that the school district is not complying is that apparently there's nothing in the code to say that the parent has an opportunity to participate in the hearing after imposing a short-term or long-term out-of-school suspension as a consequence, or to participate in a hearing. So again, it's not saying that Fall River isn't doing that. It's saying that the Code of Conduct does not include a section that says that. And then not picking on Brockton, but you know, looking at their Code of Conduct currently, it does not seem to comply with the new law. So here again are specific statutes, specific regulations. And for example, it says oral and written notice are provided to the student and parent in English and in the primary language of the home, if other than English, or other means of communication where appropriate. That is not in the Brockton Code of Conduct at this point. So this is obviously a really useful tool just to go through and say, is this in there, is this not? If you are interested in doing this for your district, again, I will be able to get you their tool, this spreadsheet that they are using, but it may be, because they have been doing a lot of districts just to see, it may be that they have actually already done the district that you are working with or working in. So if you want that information, I would say actually contact me as well, and I can see which districts have already been completed. Okay, so that was just basic compliance. Are they doing it or not? But now, what do we do if they are or aren't? So let's talk about advocacy. Okay, so like I said, just remembering that every school should have a recent updated code of conduct. This law is brand new, and so we should be seeing some change in language. So if you're seeing non-compliance, so I would say use a tool similar to Harvard's tool and lay out the non-compliance, really specifically spell out what is not in there and what your concerns are. Write a letter to the superintendent, attend school committee meetings and bring this up, meet with your principal, and kind of bring this information forward and see if you can start a discussion on changing that code to make it compliant. And again, I had in 37H, it talks specifically about for high school students, there needs to be a yearly meeting. I am not aware of a lot of high schools that are actively following that. If your high school is, or if you're working with a high school that is, that's fantastic that they're reviewing the code every year. My sense is that that's not the case, so it could be that what you are specifically asking is even just to do that. So if you're at the high school level, maybe seeing if you can point to the statute and say, hey, look, you know, there's supposed to be a review process, and I would like to start that process up and see if we can get a group of people going. There are some special education points that I want to make about school discipline, which is, first of all, you know, use the PAC authority to talk about school discipline. There is statutory authority to have an advisory and a participatory role. Part of the goal of the parent advisory councils is to advise the school committee and to meet with the officials, meet with the principals. So that's obviously a great way in to start this conversation. And then on the individual levels, really thinking about talking about school discipline at team meetings. You know, it can be frustrating if there is an incident and that is the first time that you are talking about school discipline as it relates to a student. There's so much fantastic preventative work that can be done at team meetings. One, making sure that, you know, the team has an IEP that's appropriate for the student's individual needs. And being specific in the IEP about the student's challenging behaviors can be really helpful. Or what you worry about or anticipate might be an issue, this can be incredibly helpful in a manifestation determination hearing where you're, you know, having the conversation about whether there's a correlation between the disability and the incident. Especially if you have an IEP that has very specific information and then you have an incident that's very similar to that specific information. I've seen a lot of IEPs that are, you know, where students have been diagnosed with emotional disabilities and are in therapeutic settings due to their behavior, and yet the IEP is very vague and not super helpful. So again, really thinking about that in terms of prevention. And also just looking through the student handbook to make sure it has the appropriate procedures for discipline of students with IEPs. Some are very clear about it, and some student handbooks, I should actually just talk about that for a minute. Some of the student handbooks are incredibly detailed and very, very well done and thought out. Boston, for example, has a very detailed code of conduct. It is, I think, about 60 pages long. There are some other districts where the student handbook isn't very long. It's even just a number of pages. It has what's required in the statute and then basically has some sort of kind of catch-all language. Or we'll say, all of this needs to be done in compliance with federal and state special education regulations. See if you can and have a conversation and start a conversation about making sure that that's a little more kind of spelled out in terms of what that means. Both in terms of making sure it's correct and also, making sure that there's then more information available to students and parents. As I'm sure some of you have experienced, the manifestation determination can be a very complicated process, and it's not sometimes explained incredibly well to families that are going through that situation the first time. So the more that can be spelled out, I think the helpful for everyone in terms of the broader education. I do want to note, though, that Chapter 766 approved private schools are not actually obligated to comply with 222. They have special procedural requirements. And this is just a summary, but essentially there needs to be immediate notice of suspension to parent or DCF in the school district, written statement explaining the suspension to parents, DCF in the school district. Once a student is suspended 3 consecutive days or 5 non-consecutive days in a school year, there's supposed to be a meeting to talk about what's going on and to prevent further discipline. And then the private school can terminate a student, but they need to keep the student until the district finds an appropriate placement, and there should be a team meeting to develop a termination plan. So they, it can be sometimes complicated, the interplay between the 766 school and the school district. I've had situations where a school district is pushing discipline that the private school is not pushing, and then I've also had situations where a private school is pushing discipline and the school district is suggesting that the child not be disciplined. So it can get a little complicated, but it is important to know that those do not actually apply. They have their own procedural requirements. Okay, so now I wanted to talk a little bit about the model code of discipline in the Dignity in Schools campaign. So for those who are not familiar with Dignity in Schools, it's a coalition of more than 80 organizations across the country, and the mission is essentially to challenge push out in schools across the country and advocate for human rights of every young person to a quality education and to be treated with dignity. They made a model code. It was an intensive process. They basically spent 3 years dealing with a certain amount of states and getting very specific input. It's basically a document that has recommended policies to schools, to districts, to legislators to help end push out. And it comes from the Human Rights Framework, which is a really interesting way to have done it. The best part, though, and I think this is what makes it such a great advocacy tool, is that there was input from students, from parents, from educators, from advocates, and researchers to envision a school system that supports all children and young people in reaching their full potential. One of the things that I have found, and again, I am coming from a student advocacy perspective, but there is a big difference between me coming and sharing my opinions and thoughts and then the difference between when things are backed by researchers and when you have educators on board. Certainly that makes for a more powerful statement. So that is one of the things that's super helpful about the model code, because it did actually get input from all of those people. So the structure of the code is it's actually organized into 5 chapters: education, participation, dignity, freedom from discrimination, and then data monitoring and accountability. And each chapter includes recommendations for lots of different levels. So it's not just what should you do school or what should you do district, or how would we change this legislatively if we could. It actually has policies for all 3 different levels, which is great, because depending on what kind of advocacy you're doing, For me, for example, I would very much like to change 37H1/2. I think it's kind of overbroad, and I've seen kids with very low-level felonies be put out of school for charges that are later dismissed. So that would be something that I would like to legislatively change as opposed to on a school district level. But it gives recommendations for all of those things. So just some tips to how it's usable and how it can be a great advocacy tool is, thinking about, what is it you're trying to change? What level are you trying to change at, whether it's the school level, the district level, or the state level. And so find the applicable sections, looking at the model code and comparing it to what's in your code of conduct or what's in the policy you're trying to change or the law you're trying to change. And then using the language from the model code to support your recommendations and sharing it with decision makers that can help change law and policy. And again, like I said, it's great that it has input from so many different stakeholders because it just makes it a more useful tool to say, look, this isn't just an advocacy piece or this isn't just a school piece. This is everybody kind of coming together to see how we can help and promote student success. So, for example, if you're dealing with a district that you feel has an overly harsh drug possession policy that you would like to change, the model code is very long, so that's why I'm using an example just to give you an idea. What does the model code say? So there's very specific language in the model code. So in looking at the drug policy, so there's a specific area in the model code that talks about prevention and intervention for drugs rather than punishment and criminalization. It calls for health-based approach to student drug use and abuse using referrals and counseling services rather than punishment, and encouraging schools and law enforcement to work together to use school-based disciplinary interventions whenever possible to minimize arrests, and really trying to keep kids from being criminalized in their behavior, and if criminalization occurs, really trying to keep kids in the community as much as possible. This I know is a small slide that you can't read. I put it on there mostly just to say, look at all this information on drug policy that the model code has. So again, depending on what type of advocacy you might be looking to do or what kind of discussion, it doesn't necessarily need to be advocacy, but what kind of discussion you want to start, the model code has, just on drugs, it talks about education, elements of an effective drug curriculum, what about searches, what about resources, intervention, and confidentiality. And again, the model code also has, it's research-based, and it has footnotes throughout the whole thing as to where the research came from. So when it's talking about, elements of an effective drug education curriculum, that is backed in research. So that can be a really helpful tool to use when you are trying to suggest change to your district. The other thing it has is this, I think I mentioned, it comes from the human rights framework. Every policy in the model code has a human rights goal, which I think is just a nice way to kind of set up the conversation that, schools should provide comprehensive policies and strategies for the prevention of alcohol, drug and other substance abuse. Teachers and professionals should be equipped and trained to prevent and deal with these problems in effective and appropriate ways. So that it's starting not from a premise of, oh my God, district, you need to change this, this is wrong, but really, what is our goal? What are we looking for? And these are going to be shared goals. The goals are not, they don't point fingers at anyone. They don't say, students are the problem. Doesn't say teachers are the problem. Doesn't say administration is the problem. It just says, this is our goal. And essentially, our goal is healthy, happy students and teachers that feel equipped to deal with students. So it's a great way to kind of start the conversation in a non-adversarial position. This is my contact information. I hope that we can have some conversation and some questions with the time left, but If you have any questions about either this presentation or just wanted to have a conversation about a situation you might be dealing with a school or with a family, please feel free to call us. We have a general information line, and then that's also my direct line and email as well.
Thank you, Marlies. So we do have a number of questions already, but if you have been waiting to ask a question, please feel free to type them in now. Several of the questions that we have are concerning manifestation determination reviews, so I'm going to group them all together. But first off, Marlies, this is an interesting question to me. Are you able to modify, on an IEP, can you say that because of the challenging behaviors of a student with special needs for any reason, for any kind of special needs, including social emotional impairment, can they be made not to be, can you say they can't follow a particular part of the code of conduct?
Okay, so there, some IEPs used to have, though, there was an actual question that specifically said, can the student be held to the code of conduct? If not, why? That's not in the kind of Massachusetts approved IEP form that they use on the DESE website, but there's plenty of opportunity to have that conversation. I think you would be hard-pressed to find a district that is willing to make a blanket statement like that. To say that a student doesn't have to be held accountable to the code of conduct, but there is a piece in the IEP when you're so right after it talks about longer school year and longer day and then transportation. There's also a section just additional information, and I would absolutely suggest that be a conversation there. That if a student has specific behavior that is going to run up against the code of conduct, that you say, when the student displays this behavior, we will not use the code of conduct, and see if you can have that conversation. If the school is not willing to make a blanket statement, again, this is where you might want to talk about the specific things, the behaviors that you're concerned about, so that they're there, and maybe you can say when the student displays these behaviors, we understand that this is a related part of the disability, and maybe not get it so far as to say, the school district may not be willing to go as far as to say, and that means they won't be disciplined, but you've then got a clear, strong kind of basis to advocate for a manifestation because the team agreed that these behaviors are generally the type of behaviors that you might see given the student's profile.
Thank you. Another question. You had referred to some kind of school council reviewing the handbook or the code of conduct on a yearly basis. Were you referring to school committees or were you referring to a different kind of school council?
So I'm into, here, it's in 37H, and I can, let's see, go to slide, let's see if I can find it. Let's see, right here. In 37H, it says just the school council shall review the student handbook each spring to consider changes in disciplinary policy. So the statute just says the school council. It's not specifically clear as to what that school council means. So I would say if you're on a school council and you want to do this, then advocate that it means you. And if there is nothing, I think you can basically send a letter to the principal or to the superintendent and say, 37H says that the school council is supposed to review the student handbook. I'm unaware of a school council that is doing this. I would like to take part in this process. Please let me know. It's a strange kind of thing that's been put in the statute, but doesn't seem to necessarily reflect an existing structure within the school district. So it may exist and it may not. So I'm going to guess it most often does not. So then you want to see what you can do to create it or join it if it does exist.
Thank you again. And we also have a question from some people way out west in Pittsfield. Do you know if they've reviewed the Pittsfield Code of Conduct yet?
I don't, but I can certainly ask.
Okay, because apparently they do you guys, does Edlaw have people way out west?
So what we have now, so we are Boston based, and we are but we are statewide in the sense that, you know, our goal right now in terms of our direct advocacy is to support the underlying delinquency or child welfare attorney working on the case to do the education advocacy, and we've been doing intensive training for delinquency and child welfare attorneys. So that is our ultimate goal, but if there are situations that are extremely complicated, we may get directly involved even though we're in Boston and you're in Pittsfield. So that is not necessarily a barrier.
Okay. And someone pointed out, an SESP pointed out that even though schools may have very good policies in place and their code of conduct has been revised very well, sometimes the practice doesn't reflect what the code is.
Oh, absolutely. Yeah.
So if you could just speak to that a little bit.
Yes. You know, I mean, ultimately, you know, having a fantastic document does not necessarily translate into having excellent practices. I have been to many a hearing where I can point to a code of conduct that says, you know, that a school district will do X, Y, and Z, and the school district is refusing to do X, Y, and Z, and is kind of blatantly disregarding their own policies. So what to do in that situation? There are appeal rights in terms of going to the superintendent. If that does not work. So there's appeal rights starting at 10 cumulative days of suspension under 222, but you can also appeal short-term suspensions either because some code of conducts actually allow you to. Some districts have put that in there even though it's not necessarily a requirement under the statute. You can also do it under FERPA, which is the Family and Education Rights Privacy Act, which essentially says if you have any issue with anything in your student's record that you can write a letter to the principal asking for that to be changed, and then, you know, if the principal says no, then it can go to the superintendent. So it's essentially like having an appeal hearing for short-term suspensions if you want to do that as well. Ultimately, if you are not successful at the principal hearing and the superintendent appeal, your next remedy, which is not an easy remedy for most people, is to file an injunction and basically say, you know, bring it to court to say that the school district is has illegally done some sort of exclusion. If you're in that situation, I would say consult with an attorney. Feel free to call me and talk about any situation like that. The courts have essentially given school districts pretty broad authority. So, you know, if you have a situation, give me a call. I can run down for you, you know, depending on the situation, what the courts have said or what the chances of the merits of success are.
Okay, so a lot of people are getting very interested in the Harvard reviews that are starting to come out, and I've only seen a couple of them. So are they going to be available? Do you have any idea, Marlies, what they're planning on doing with them all? That they are?
I don't. I think right now they're just kind of doing it to get a sense of how many codes are compliant. But I am certainly happy to Michael Gregory is the one that's kind of leading that at the TLPI, the Trauma and Learning Policy Initiative. And so I will happily coordinate with him and find out whether they're going to be available, what districts they have done, and if people are interested in them doing the districts, whether they're available to do that or whether it will be that they will provide the template. So I think at the very least they'll provide a template for people to go through the codes themselves. At the very best, I can make suggestions that they do specific districts and then they do them and make them publicly available. So I will see what I can find out there, and when we get the tool, why don't we, Janie, can we then provide an update on that?
Yes, absolutely. I'll be in touch with everybody who's registered for the webinar. Okay, so another question, is there any monitoring that is put in place to make sure that the new Chapter 222 is being complied with, and that would go along with the revisions of the Code of Conduct? So kind of who's in charge of making sure it happens? Or
Well,
is there no one?
Kind of right now, there's not specific oversight in that. There is, the new law did add some data requirements in terms of school districts having to report on who is suspended. That's now better than it was. It used to be that they only had to report on students that were suspended long-term or students with special needs, but now they are required to report out any suspension, and they are required to do that with disaggregated information on age, race, gender, disability status. So there's more data there. There isn't any specific oversight to say you need to comply with the law in terms of updating your code. It's just this is the new law now. They should have a new code to reflect that, and they need to follow the law. So if they don't have an updated code, it could be that they just haven't updated it, but they're still, following the law. And if that's the scenario, then I don't know that it's specifically against the law that your code isn't up to date, although it really should be, but I just don't know what the remedy would be for that, is if they are actually following the law. And if they're not following the law, whether it's in the code or not, it goes back to those other options I was talking about earlier, the appeal and, at worst case scenario, injunction.
Okay. Here's a very interesting question. How does the school make sure that kids with intellectual or social disabilities are understanding what the Code of Conduct requires of them?
That is a very interesting question. I don't think that it specifically discusses that in the statute. I think, though, when we look at what is required here, I think you could make the argument that, by requiring that there are procedures pertaining to discipline of students with special needs, that that would require that they also actually have to understand what those needs are.
That would actually be a very good IEP goal.
Yes. Absolutely.
Yeah, that they would, that would be one of the things that they would be working on, is to understand the codes of conduct. Also, someone asked the data that's being collected from Chapter 222, is it going to be posted by school district or on the DESE website?
It'll be posted on the DESE website. So the school districts are required to give that information to DESE, and then the new law basically says it will be available in the fall of the next year. So the first data that we'll see under the new discipline law should be available in the fall of 2015.
Great. So let me just put it to you this way, Marlies, so that I think that the manifestation determination reviews and that whole procedure gets a little confusing as far as how it overlaps or is different from Chapter 222. So maybe you could help people understand a little bit about the difference, and if
Sure.
there are really big difference now between special ed kids and typical general ed kids.
Okay, so special education students have had a right to be educated during a period of exclusion longer than 10 days. That's part of IDEA. So what does it mean now to have this 222 kind of alternative ed piece? They are different in that, students with special needs are entitled to the services in their IEPs to make sure that they're still able to make progress towards their IEP goals. That is stronger than what is required of regular education students, which is essentially that there needs to be an education service plan in place that give kids two options. They have to have at least two options to make educational progress. So the services could be just online learning, it could be tutoring, it could be alternative school, but it is not specific to the IEP goals. So So one thing we have seen a couple of times is school districts basically trying to offer their special education students the same thing that they are offering now under these education service plans for their regular education students. And depending on the level of need of your student, that may or may not be okay. But most often I would argue that unless it's very specific to the child's IEP needs, it is not okay. So it hasn't changed anything in terms of the rights of students with special needs to make progress towards their IEP goals. If they are excluded, it just is now for the first time offering regular education students some sort of educational services. I do think that at some point that issue is going to be litigated as to what those educational services need to be because it's fairly broad right now. And I think there are going to be some complaints as to what some school districts are suggesting for those plans. And for your special education students, you know, again, it has to be towards the progress of their IEP goals. Some school districts try and do, you know, a standard issue 4 hours a week of tutoring or something like that. And then again, it's going to depend on the needs of your student as to whether or not that's appropriate. You know, it's supposed to be an individualized determination, and I think this is a huge area of where I think there could be a lot more pushback as to what districts are offering in terms of the special education services during a period of exclusion.
And the other thing is, I think the difference between the two laws, IDEA and Chapter 222, is that when the IEP student is removed, there has to be effective progress made on the IEP goals, whereas I don't think there's any ability to measure progress for kids that are suspended or removed under Chapter 222. Is that correct?
Right. It just says there, you know, there needs to be given the opportunity to make progress, and you know, there are going to be these services offered. And again, I think that one difference is, you know, there are so many due process protections for students with special ed that you know, you have the BSEA you can go to if you don't think that the services are great, whereas, you know, the process for a regular education student has yet to be kind of determined. But I think the standard, you know, generally for education things is arbitrary and capricious, which essentially means that unless the school district is kind of knowingly doing wrong, they have a lot of discretion, whereas it's certainly a tighter standard for students with special needs.
Okay, and one of our listeners is telling me that the Children's Law Center, that's you, right, Marlies?
We're a partnership with them, yeah.
That's what I thought, yeah.
Yeah.
They have a great colored chart on the website about basic advocacy steps, which I've not seen.
Yeah, so actually we created that with the Children's Law Center.
Okay.
So we have 2 quick reference guides, one on special education and one on school discipline. They are available, I can tell you off the top of my head where they're available on the Children's Law Center website, which is www.clcm.org/publications. And it's in there, it'll say quick reference guide to special ed and quick reference guide to school discipline. We also have some hard copy laminated ones if people are interested.
Yes, we all love those. They go quickly at the resource fairs. Okay, I don't have any more specific questions unless we have like 2 minutes left. If anybody has one last critical question they want to type in, and we can answer, or hopefully Marlies can answer. This has been very, very informative for me, and I think it's really let people see the flow of the whole Chapter 222 and what, you know, how it kind of trickles down to the student through the Code of Conduct. So thank you so much for illuminating it much more than I think a lot of people have been able to figure out.
I'm just going to slide back on my contact information.
Okay. Oh, yeah, for your particular.
If anybody has any questions.
And they did get the, hopefully everyone got the PDF of the actual presentation Some of them did bounce back, so if you did not get it, please just contact me, Janie, and I will send it back to you. So this will be on the PDF. And thank you very much, Marlies, and everyone else. And we will talk soon. Bye-bye, everybody.
Thank you, everyone.